So we'll start with Section 1, Amendment 1. And Tara, do you move?
Yeah. Thanks, Chairman. This amendment counterfastens the intention of Deputy McLaughlin's bill, which is to introduce a legal prohibition on onshore fracking. It does not in any way change the objective of the bill. The language in this amendment has had the benefit of the advice of the Office of the Attorney-General to ensure legal robustness and certainty with regard to the introduction of this prohibition. I would like to move the amendment. I'd like to acknowledge, first of all, the support for Deputy McLaughlin's bill across the House of all parties and independents, and acknowledge his role in bringing this bill thus far, and also to commend the members of the committee in relation to the launch of your report on the detailed scrutiny of the bill a number of weeks ago laid before the House of Directors on the 12th of April. And in that, in your recommendations on page 57, you stipulate that there was 4 recommendations. In certain sections, the terminology of the bill should be revised. You asked for an enforcement mechanism should be included in the bill, and any potential drafting deficiencies of the bill would be best addressed during the committee stage debate of the bill, and that you asked that the Minister, with the assistance of the Office of the Parliamentary Counsel, could propose amendments to rectify any drafting problems by drafting a suitable amendment at either committee or report stages of the bill. And you also asked for the scope of the bill should be expanded to take account of other activities, such as those that use geothermal technologies, which may be used to access shale gas through other means. So what the amendment does, in fact, is ensure that certainly the first 3 of those recommendations are taken on board, that the terminology is revised, that there is an enforcement mechanism including an offence and penalty, and that there are any drafting deficiencies are rectified in these amendments. So, as I said, I'm not sure do I need to read the amendment. It's there before you, but it better clarifies what hydraulic fracturing means. It states quite clearly under Section 5B that notwithstanding anything of this Act or any other enactment or rule of law, it shall not be lawful for a person to search for, get, raise, take, carry away, or work petroleum by means of hydraulic fracturing. And it goes on to state that a person who contravenes this shall be guilty of an offence and shall be liable on summary conviction to a Class A fine or term of imprisonment. So that's quite clear that this bill does this amendment does what Deputy McLaughlin's intent and what the committee intent and what everyone intended during the second stage debate. It ensures that the language is cleared with the Parliamentary Council, with the Office of the Attorney-General, and to ensure that the prohibition stands. I move this amendment. We were quite conscious of the need to include the word prohibition. I know it was in the original title, but because this was an amendment, this now becomes an amendment of the Petroleum and Other Minerals Development Act of 1960. We wanted to ensure that the word prohibition was included. So we have, this Act may be cited now as the Petroleum and Other Minerals Act, brackets, Prohibition of Onshore Hydraulic Fracturing Act 2017.